Hello, in today's video I am going to explain what a whistleblower is, and we are starting right now. Hello, welcome to my channel. My name is Brandon Ortiz. I am an employment lawyer in Santa Monica, California. Before we begin, let me just remind you that this video is for informational purposes only. This video is not legal advice. If you have specific questions about your needs and your situation, you should contact an employment lawyer. If you are in California, you can contact me at 888-376-7849. 888-376-7849. Today I am talking about whistleblowing for purposes of a whistleblower retaliation or wrongful termination case. Whistleblowing can mean a lot of different things depending on the law that you're talking about. You may have heard of whistleblowing in another context. There are certain types of lawsuits you can file against companies that are defrauding the government. Those are called qui tam laws or False Claims Act laws. California has them. The federal government has some. We're not talking about those today. Today we're talking specifically about the employment context and whistleblower retaliation against an employer, against the employee. And we are primarily going to be looking at California Labor Code section 1102.5. That's the most powerful whistleblower statute in California. I'm not going to be talking to you about other, there's federal whistleblower statutes, there's even other California whistleblower statutes. And we're not going to talk about those specifically today. However, some of these concepts also apply to those other laws. Now, what does it mean to be a whistleblower? 1102.5 protects employees who disclose information that the employee reasonably believes discloses a violation of state, federal, or local rules, regulations, or statutes. Now that's a lot, so let's unpack that a little bit. Disclosure of information being the first part. That sort of begs the question, do you have to disclose that it's violating the law? Or is it enough for you to disclose information that you happen to believe discloses a violation of law, but you don't actually come out and say that it violates the law? Like let me give you an example. Let's say that you report that your employer is dumping toxic waste into the river, and you make that complaint to the Environmental Protection Agency. But you don't come out and say that, hey, I think that's violating environmental statutes. You just report that they're dumping the toxic waste into the river. Well, if you happen to reasonably believe that that is a violation of law and that your report is revealing a violation of law, that is protected. There's a case called Ross versus County of Riverside that says that. It's a different fact pattern. It's not a toxic waste fact pattern, but that's what the case says. All the law requires is a disclosure of information. That's all it requires. If you reasonably believe that it discloses a violation of law, then it's going to be protected. Now, that brings us to the next component of it, the reasonable belief. What does that mean? That has an objective component and a subjective component. The law is looking at, did you personally believe that? That would be a subjective component. And was that belief reasonable? So let's give an example. Let's say you complain that I don't like the color of the walls in my office. Well, is it reasonable to believe that it's illegal to paint the walls a certain color? Probably not. In fact, I would say most definitely not. I'm not aware of any laws that say that, and I doubt anybody could point to a law that says that the walls have to be painted a certain color. Now, maybe in different contexts, if you're talking about, safety vests have to be a certain color, they have to be orange or neon yellow. Maybe there's an OSHA reg somewhere that says that. But, in the context that I just mentioned, complaining about the color of the walls, it's probably not going to be protected. Complaining about the vending machines having Pepsi products instead of Coca-Cola products, well, there's no law that says you have to have either Pepsi or Coca-Cola or both. So complaining about that, that's objectively not going to be a reasonable complaint. But what if you complain about something, but the belief is objectively reasonable, you turn out to be wrong? Let's go back to the earlier scenario. You see your employer dumping a substance into the river. It has a chemical waste logo on the barrel, and so you see them with this chemical waste barrel, and they're dumping something into the river, and so you report it. You say that they're dumping chemical waste into the river, and it turns out that actually they were just dumping water, and there actually wasn't any chemical waste. Are you protected? The answer is yes. It's the standard is whether or not it's reasonable. And based on what you witnessed, it would be reasonable to infer that there was chemical waste inside the barrels, given that it had a chemical waste logo on it. And so the law protects the reasonable but mistaken belief because the law wants employees to come forward and make these complaints. Now, under 1102.5, not every complaint to every person is going to be protected. You do have to complain to specified groups that are listed in the statute. One could be a supervisor. Another could be a person with authority to investigate or correct the non-compliance with the law. And the third would be a governmental agency. So it's only protected under California whistleblower statutes if it's to a person in one of those three categories. So let's say that you tell your spouse that, hey, I think my employer is dumping waste into the river. And somehow or another, the employer finds out about it and fires you. Is your conversation with your spouse going to be protected conduct? Unless he or she is one of those three categories that I just specified, it's not going to be protected. Now, if your spouse happens to be your supervisor, it'll be protected. If your spouse happens to work for a governmental agency and you complain to him or her, it'll be protected then. But they got to fall into one of those three categories of individuals. What about complaining to a coworker? Is that going to be protected? No, it's not. What about holding a press conference and announcing that the employer is dumping waste into the river? Is that going to be protected? The answer is no. Media are not one of the three categories of individuals within the law. So you'll hear a lot of stories where there have been some leaks at some high-profile employers, and they've been called whistleblowers in the media. And in a sense, that label is correct, but legally speaking, from the perspective of employment law, are they whistleblowers for purposes of employment law? No. Leaking things to the media is not protected activity under the law. Now, testimony to Congress, that is going to be protected. However, a lot of these cases we're seeing them being called whistleblowers for things they sent to the media, documents that, they forwarded to the media. That's generally not going to be protected. Thank you for tuning in. If you made it this far into the video, that means you found the video to be informative. I would really appreciate it if you could click like, hit subscribe so that you get notified when I post videos in the future. If you have any suggestions for videos you think I should make, please leave them down below in the comments. And if you need an employment lawyer in California, you're welcome to call me 888-376-7849. 888-376-7849. Thank you.